Pleased to see you again. So, you are not concerned of a student rights. Eh? How do you perceive this class of is communal member? You consider that perhaps you will see primary and elementary students of primary and secondary schools. Well, actually, they are distinct categories in the community. Perhaps they would not be viewed as due for any Bill of Rights concern, and we have once discussed the position of Supreme Court about due process of law context. You consider so how much the school authorities would exercise a discipline or any search and seizures in the school zone, and what kind of a locker room search and body search, corporal punishment, and the partisan politics would promote any changing core policies, implications, or we are expected to keep a state decisive rule in any ultimate frame, responsibility. You might, in some cases, the rigidity of a principle rule might be challenged, even in judicial branches. What is Hannah case? And the court will see in as you conform on the pages in a printout. For example, the court would, in some cases, which is quite exceptional and rare, about some guess from the expected outcomes in the Supreme Court that should not be undertaken in any paradigm of law and what common law tradition is. Ultimately, based on that concept, they should operate any due respect to the precedents, and so actually they would explore about the ranks of relevant jurisdiction, federal, state, and what a appeal court, and in some cases provincial court. They search for the cases of equal length, and of course the binding power would arise from a precedence of a higher court. So they would exert every exercise of a search for a relevant cases, and might analyze to make pertinent rule. What is also a precedent to be obeyed by subsequent courts. You consider. That is not the typical way we expect. However, in Hana case, the court learned in some aspect while they contested its miscarriage about a state decisive rule. So we have been let another way. So our issue is now on student rights, and the mood and evolution in this public issue would quite stuck, as you will see. Romania is very representative, notable about a cohesive Bill of Rights concerning students and groups. And United States and Canada, as well as other jurisdictions on the planet, would follow critical need about this class of communal members. How do you place this class in any meaningful terms about public policy? And most jurisdictions, unlike Romania, would have extended Bill of Rights, but generally not cohesive. You consider, for example, scope of pronounced regulations and principles to deal with the rights and interests of students. What is equipability rights? What is right to protection from arbitrary or capricious decision-making? Right to have institutions follow their own rules. Right to adherence to bulletins and circulars. Right to adherence to regulations. What are others? Right to protection from, right to fulfillment of verbal promises, a right to notice of degree requirement changes, right to continuous contract. So actually, they are vulnerable in bargaining power and other individual status in the community. You well expect. And actually, the students has long been treated culturally. They have no any formal response. For example, the nature of institutional nature about their rights and privileges. So that would be a concern, basically, to develop into any meaningful framework in terms of public policy. And we also consider which perhaps is eclectic in their characteristic. They are learners actually in other dimensions, and the lifetime phase to be bred and grow. So how do we shape adequately to respond with that distinct status? It's actually, you know, the American concept. For example, they approach generally the concept of student government or student association, which centers on the concept of learning and democratic participation about the school policy and administration. In contrast, the attribute now pursued in the European context might be very elevated. They rather see themselves as a union concept. They would rather be focused on so what is the union concept? And they are occupational in the course of the movement. Nonetheless, still meaningful, as you see the differences now evolved between two continents. So, how let's see, the current phase in the educational reform might quite consequential to produce a different outcome in both continents. So they now progress on Erasmus and some integration of public education in a single commitment. So actually, you will know some basic policy about the European Union. So they are a mid-term of a union in terms of our general understanding in this constitutional structure and others. They are founded on a basic treaty, what is called Rome Treaty, and you will know the branches and departments. You know also perhaps the concept of bureaucrats. What are bureaucrats? They are elected in some sphere. European Parliament now are comprised of elected members, direct chosen by national votes. So we have recently heard the extreme rise in partisan politics of Europe have prevailed to be held into seats of a European Congress. What does it implicate in integration of European Union, or perhaps might be disintegrated to a minimal extent of union? Other alternative might well be vitiated in that advancement. And you also know the cases of a veto France about one unitary scheme of a European constitution. So they still now operate on the basis of an international treaty, which is deemed as a quasi-constitutional to rule and administer the European policy. So it actually in dynamism, on progress, and in some sense tumultuous about its true nature of as a policy unit in our consideration. So the Erasmus project is related with educational aspect of European integration. So now the transfer of academic credits have been endorsed at the level of European institutions. So the national students have now actually faced with a quite encouraging phase to raise their voice and largely the interest. So they rather lobby to promote their interest and rights. That is a point of departure from the United States context in terms of a student movement about a Bill of Rights and other. So and also they actually are quite near to the occupation areas, and you will know the extent of integration is quite strong in the European Union, which actually now practice the free labor mobility. So, and perhaps a very neat fashion of a social benefit about the different origins of nationals. So, and also now implement the uniform policy about trade, and also a financial decision to be significant about European values and others, and they use a common unit of currencies, what is called a euros. So the completion of Erasmus project will seem to be near, and their loving influence is very echoing about shaping of a European policy in harmonization and others. So that is one factor. You have some awareness between when you consider student rights. So actually, the educational dimension is considered to be a important component about a public policy. Feels is distinct to project of a long time span. You consider how to breed the student is important. We once have recollection of a past crisis about educational terms from the challenge of Sputnik. So how the Russia has excelled in the competition of space, the United States. So that might impose the field of crisis, and any might well be employed in due terms about public policy making. And other through the cases to be dealt in this class, you will also double check some important lessons. For example, what is that? What they taught in the previous class. What are those? For example, the recusal of a Supreme Court justices, state Supreme Court. That policy principle has been applied through the adjudicative or proceeding they conducted by commissions and public commissions and agencies. The commissioners should be excluded, disqualified to administer the dispute and others. And we have shared concern about export communication or other evidence. Gathered by extraneous sources. So have been illustrated involving several proceeding court So the outside persons from foreign nationals or would be actually be captive about the social pressure. Impression is led very strikingly about as possible unfairness about due treatment in judicial proceedings. Nonetheless, I have appreciated the civilized system of a criminal justice in South Korea. So the court would not adopt any extraneous evidence, ex parte data or information collected by ex parte communication. The evidence should be produced in the courtroom to be considered. And the federal rule of criminal or civil procedure would detail the admissibility of evidence, or a poisonous tree doctrine, or others. And the kind of a due process values would be reincarnated. But how much extent should be afforded, unless it would not be invalidated by oversight court and others. So the extent would not be the same. And I have mentioned the laws and some also quite dubious, for example, about this definite description generally on that issue. So, for example, the court also could not be formally settled, depend on the circumstances and others. So what the entirety of a circumstance, totality of circumstances, for example, might only be related criminal system in South Korea. That is not true. The idea or some basic ways of approach would also influence to guide the extent and due response from the agencies. So, for example, we see universal camera corpus, NLRB, and others. And actually, you will perhaps room into the Federal Administrative Procedure Act, perhaps most paradigmatic standard to guide the public agencies. And in this statute, you will be exposed to a variety of issues and the statutory dealings about the subject issues dealt in this class. For example, judicial review has chapter number 7 about its application, definitions, right of review, form and venue of proceeding, actions reviewable, relief pending review, and scope of review. And for example, you will consider section 701. This chapter applies according to the provisions thereof, except to the extent the statute precludes judicial review. Agency action is committed to agency discretion by law. For the purpose of this chapter, agency means the judicial review is in principle comprehensive, but might be limited by ways of exception. So statute may preclude judicial review. So the discretion is one other important element to be contemplated about this frame. And the statute spelled out the right of review. A person suffering legal wrong because of agency action or adversely affected or grieved by agency action within the meaning of a relevant statute is entitled to judicial review thereof. An action in a court of the United States seeking relief other than money damages and stating a claim that an agency or an officer or employee thereof acted or failed to act in an official capacity or under color of legal authority shall not be dismissed nor relief therein be denied on the ground that it is against the United States or that the United States is an indispensable party. So actually we have also explored the liability of government as one subtopic for this class purpose. So we have recourse the kind of points of consideration about this different treatment, and we find the public cause to be attributed to the role and responsibility of government may not make a same between private relationships and public relationships. So and in due context, the commercial activity exception would also is corroborative about that point. So actually the government is sacred. So we considered what the ideas and the ideology that the government has ultimately destined to promote, you say, general welfare and others. So public cause is quite sublime. And the intrinsic function is inviolable, and should not be attained by equal terms of a liability. A private relationship is mere commercial. You can be evil, and also the other party may have chance to be faulted about on their dealings and terms. So equal, you are both equal, and the theory and concept should be made distinct to address that characteristic, and we therefore have exception, state immunity, and many statutory schemes have been noted, as I mentioned in the last class, and on the color of government, and also the Hegelian concept about idealism on a state entity would also be exchanged in comedy, and so the exemption would be granted about a foreign exercise of foreign jurisdictions. The national court will grant a due difference and perhaps practice non-intervention or any withhold the competent jurisdiction otherwise with the national entities or about a foreign government and others. So, and the scope of foreign government also might be disputed. For example, Korean Asset Bank is a foreign government within the meaning of a State Immunity Act in the United States. So judicial review involve the government of the United States. And also the concept may be divergent to be cohesive in classification about terms and provisions of statute. The governmental branches might well be conceived to meet the standard that should be treated as United States or Republic of Korea. Korean asset has been adjudicated from the judicious finding of a district court in the United States about its total liability. Nonetheless, the court ultimately rejected the claim about total liability against Republic of Korea, since the activities now raised in the court controversy, as a controversial case in courtroom is commercial in nature. So, and that also enable the conditions to be active about exceptions and any expansion of rules into what is effect theory, and the what extraterritorial application might be questioned in some cases about the activity of foreign government may be challenged in due terms in the National Court of the United States if it may affect within the territory of the United States. So exceptions and limitations might be set forth and developed through the trajectory of relevant cases or period of time. So the United States in judicial review may be named as defendant in any such action, and judgment or decree may be entered against the United States, provided that any mandatory or injunctive decree shall specify the federal officer or officers and their successors in office personally responsible for compliance. And nothing herein affects the other limitations on judicial review or the power or duty of the court to dismiss any action or deny relief on any other proper legal or equitable ground. Second, confers authority to grant relief if any other statute that grants consent to issue expressly or improperly forbids the relief which is sought. And the statute also has provided the form and venue of proceeding about the judicial review, and subject actions reviewable, and also dealt with relief pending review, scope review. So the statutory scheme is very dispositive, and many important parties' controversies were actually settled through enactment, and this is typical example we consider. And many civilized system about soft nature of deals in public administration have also be identified through your reading of a statute. For example, and also a piecemeal nature of a measure would be found in for example, Nazi war crimes is important example to be direct and incorporate into their statute. The judicial review is a high nature of a remedial method. So resolution might be strictly based on laws and constitution and statute and the precedents that's conformed by a code. In other aspect, we also the critical need to promote the alternative means of dispute resolution. So in Section 3 of Public Law, as amended by provided promulgation of agency policy, each agency shall adopt a policy that addresses the use of alternative means of a dispute resolution and case management. In delivering such a policy, each agency shall consult with the agency designated by or the interagency committee designated or established by the President, the Section 573 of the United States Code, to facilitate and encourage agency use of alternative dispute resolution on the subchapter. And the adjudicative rulemaking and the negotiated rulemaking have been deliberated by drafters of statute. And in that case, we may, in some circumstances, use non-attorneys. Often representation of parties is compelled to hire the attorneys, which is actually serving to facilitate the safe defense about the deprived parties and others. Nonetheless, we will see some exceptions. For example, each agency in developing a policy on the use of alternative means of dispute resolution, this Act, shall develop a policy with regard to the representation by persons other than attorneys or parties in alternative dispute resolution proceedings, and shall identify any of its administrative programs with numerous claims or disputes before the agency and determine the extent to which blah, blah, blah. And other interesting issues about public exams to step the public office and personal affairs, which is basically a organic statute and the kind of a omnibus to respond with the need of public agency. Statutes is straightforward and crystal clear. So the president will be expected to collaborate in stepping the public office, and also how to administer the public exams to recruit the public officers or others. And the piecemeal response might also be found in Freedom of Information Act exemption for certain open skies treaty data. In general data with respect to a foreign country collected by census during observation flights conducted in connection with Treaty on Open Skies, including flights conducted prior to entry into force of treaty, shall be exempt from disclosure under the Freedom of Information Act. An executive order, as I have stated in previous class, is important instrumentality between the political legitimacy of new president and what actually consistence of a administrative practice irrespective of a change of government. For example, the executive order would be inserted in due ranks with the statute, executive order number 12600, titled Pre-Disclosure Notification Procedure for Confidential Commercial Information, by the authority vested in me as President by the Constitution and Statute of the United States of America. And in order to provide a pre-disclosure notification procedures and the Freedom of Information Act concerning confidential commercial information, and to make existing agency notification provisions more uniform, it is hereby ordered as follows. Section 1, as you confirmed in the printout, the head of each executive department and agency subject to the Freedom of Information Act shall, to the extent permitted by law, establish procedures to notify submitters of records containing a confidential commercial information as described in Section 3 of this order when those records are requested under the Freedom of Information Act. So I have mentioned the Nazi war criminal record interagency working group. Even upon the lapse of a extended of time, Nazi war criminal still is a public matter, as you occasionally experience in the newspaper articles and others. By the authority vested in me as President by the Constitution and the laws of the United States of America, including the Nazi War Crimes Disclosure Act, it is hereby ordered as follows. So, establishment of working group and schedule. The working group should complete its work to the greatest extent possible and report to the Congress within 1 year. Membership would encompass in due distribution of the competence and fairness. Secretary of Defense, Attorney General, Director of General Intelligence, Director of the Federal Bureau of Investigation, Director of the United States Holocaust Memorial Museum, Historian of Department of State, and 3 other persons appointed by the President, the Senior Director for Records and Access. So, the stakeholders and related offices will illustrate it. And also, we have discussed the aspect of negotiate rulemaking, which actually very consequential about the public rulemaking, typically less than rulemaking, and the court also recognized this concept. So the statute provides the provisions which concern negotiated rulemaking committees. For example, the Director of the Office of Management and Budget shall, within 180 days of the date of enactment of this Act, take appropriate action to expedite expedite the establishment of negotiating rulemaking committees and committees established to resolve disputes under the Administrative Dispute Resolution Act. And as reiterated, the Office of Management and Budget is central to supervise and administer the value of a project and programs. So it is a key avenue to be converged about contest and often very effective instrumentality to control a scope of public agencies in political responsibility of White House. And of course, the Congress is important authority to define the Organic Act, as we have surveyed. For example, in case FDA versus Brown and William Tobacco Corporation, the court has ruled that agency may not regulate that agenda where Congress repeatedly denies an agency the power to regulate a particular area and develops a comprehensive regulatory scheme outside the control of the agency. We have just scanned this case entitled. Actually, the FDA intended to apply the nicotine policy. They find the statutory language, drug, for example, devices, in its definitional scope. So the FDA is of course, a important statutory interpreter, and argued the nicotine was drug. And also new products will note the cigarettes and smokeless tobacco, and that are also coupled with term devices that deliver nicotine to the body with the meaning of the FDCA, so Food and Drug Control Act. In the circumstances related with this case, Congress enacted a number of tobacco-specific laws after the FDCA. And the FDA had never exercised any control over tobacco. So that created the impression and also basis of a co-finding that the Congress repeatedly denies an agency the power to regulate a particular area. So in this case, you'll consider the aftermath, responded with new enactment. So Congress passed the Family Smoking Prevention and Tobacco Control Act, which expressly granted the FDA the power to regulate the tobacco industry. The act was signed into law by President Barack Obama on June 22nd in 2009. So actually the President, Congress, and public agency all would learn from the core rules and might be responsive to respect the code and of course, in the purpose to promote general welfare of a American citizen here. And also the discourse need to be reflected seriously about the rule of law ideas. How do you consider the work and elaboration of National Assembly in a republic here about the judicial oversight? Are they facile or to be responsive, for example? Consider, for example, the notorious case about public education, Brown versus Board of Education. This case is actually revolutionary from the past paradigm about segregation in the public schools. You know the important case titled Pless versus Ferguson decision of 1896. And in that case, the Supreme Court is concerned of equal protection of laws. The public facilities have been questioned about equal treatment between two parties, and the court sustained separation given the status and a level of a service among the separate facilities might be conformed. So the policy has been endorsed in 1896 by the United States Supreme Court case of Pless versus Ferguson, which held that as long as the separate facilities for the separate races were equal, but in this case you might have some imagination about the classic cinema, perhaps train scenes about compartments with separate. So actually, the train situation was raised, and the court's viewed it did not violate the 14th Amendment. The plaintiffs in Brown, the Brown case was developed from the city of Topeka, Kansas, in the United States. This called for the District of Kansas in 1951, perhaps during the time of Korean War. And plaintiffs were certain Topeka parents on behalf of the 20 children. Actually, quite consequential, as you see later in some armed conflict. What is it? Armed conflict? The Arkansas National Guard were called into duty about segregation and this a tragic aftermath about a public disagreement and other. So how do we tolerate the same space in public education? And actually, the president has decided to federalize the Arkansas National Guard in the effort to ensure public peace. And in this case, you know the court reached in unanimity in And the consensus building also has bring a wide repercussion in academia, and many intelligent follow-ups. Actually, this case was engineered by the initiative of UNESCO, which is alleged, of course, not actually. I said the expert communication should be excluded. Also, in some negative response, you will discern some close down of a public schools in the state of Virginia, for example. So they would not operate the public schools given the court opinion is governing the context. So private stakeholders would be discontent, would exhibit discontent in some extent. And the consequence also provoked new treatment about desegregation or others in court. And Linda Brown Thompson later recalled the experience in 2004 PBS documentary. Let's have some words, which is convivial, the diverse. Well, like I say, we lived in an integrated neighborhood, and I had all of these playmates of different nationalities. And so when I found out that day that I might be able to go to their school, I was just thrilled, you know. And I remember walking over to summer school with my dad that day and going up the steps of school, and the school looked so big to a small child. And I remember going inside, and my dad spoke with someone, and then he went into the inner office with the principal, and they let me out to sit aside with the secretary. And while he was in the inner office, I could hear voices, and hear his voice raised, you know, as the conversation went on. And then he immediately came out of office, took me by the hand. We worked home from the school. I just couldn't understand what was happening because I was so sure that I was going to go to school with Mona and Gibeona, Wanda, and all of my playmates. So the consequence is also interesting that the high school in Topeka was a subject in this controversy was designated as a regional national registrar. So one popular place in travel plan for the American citizen. So NAACP, a voluntary association to promote the cause and public ideas, and the should call for the school district to reverse its policy of racial segregation. A separate elementary schools was operated by Topeka Board of Education under 1879 Kansas law, which permitted districts to maintain separate elementary school facilities for black and white students in 12 communities with populations over 15,000. And as I've said, the plaintiffs had been recruited by the leadership of Topeka NAACP. Sorry, the case involved elementary school, not high school. The Kansas case was unique among the group in that there was no contention of gross inferiority of segregated schools' physical plan, curriculum, or staff. So other context may be compared. For example, Delaware case is also unique. Not everyone accepted the Brown versus Ford educational decision. In Virginia, Senator Haley Burr organized a massive resistance movement that included the closing of schools rather than desegregating them. And Texas Attorney General John Ben Shepherd organized a campaign to generate legal obstacles to implementation of desegregation. So that is also a point how the public agency, or in this case, a Supreme Court, would coerce to intervene into a private spheres, education. In some cases, the Topeka Middle School has been integrated since 1941. Topeka High School was integrated from its inception in 1871, and its sport teams from 1949 on. So Arkansas Governor Ober Favors called out his state's National Guard, as I've said, to block black students' entry to Little Rock Central High School. So you would suppose some a popular scene in the Korean context, a struggle between the public police and infuriated public mob, picketing. President Dwight Eisenhower responded by deploying elements of the 101 Street Airborne Division from Fort Campbell, Kentucky, to Arkansas, and by federalizing Arkansas National Guard. So, also consider the case in more depth, titled United States Department of Justice versus Reporters Committee for Freedom of the Press. In this case, the press was highly interested in some of important information about herald the context of a corruption between in this case a tremendous amount of defense contract have been unethically negotiated between the congressman and local important person, families, and FBI. The Federal Bureau of Investigation disclosed any criminal records in its possession concerning 4 brothers whose family company allegedly had obtained defense contract through an improper And actually the code has delineated very scrupulously about the public need of information disclosure and also privacy of some people. How do you assess the financial aspect of information on person and individual? That would not be serious to intrude the privacy of an individual. How about a criminal record? That might be classed in more concern as should be confidential in more chances. So a categorical matter also need to be contemplated. And also I advise to read through briefly the forward provisions. And in case titled Universal Camera Code versus NNRB, the court confirmed the rule of substantial evidence. So if the administrative findings were supported by substantial evidence on the record, the court would not disparage it, as often default in due respect to the decision of a public agency. So National Labor Relations are public agency about union issues and others. And Universal Camera Code fired an employee who testified under the National Labor Relations Act. The National Labor Relations Board ordered Universal Camera Code to reinstate the employee with back pay and to cease and desist terminating employees for this reason. Actually, it was appealed in a way of certiorari to the Supreme Court. And the Supreme Court resolved the circuit split. Justice Frank Fruta delivered the opinion of the court. The court discussed substantial evidence test established by court in Consolidated Edison Company versus NNRB, which interpreted the Wagner Act, the original National Labor Relations Act. The Act provided the findings of both as the facts, if supported by evidence, shall be conclusive. So based on the legislative history and its provisions, expressed imply the court supported that the administrative finding deserves a due difference. And also consider, for example, other cases. Time is up. So for your further review. Okay, so I hope you will be successful in your exam performance during the week. And of course, I must say you have to enjoy summer vacation. Thank you for your attention. See you in the next term.